Hello my dear learners, a very good evening everyone. I am Shashank and I welcome you all on English Medium Prep by Exampur, which is a complete English medium YouTube channel. So students, very good evening everyone and welcome to the session, and please confirm your attendance as well. Then we are going to start today's discussion, and today we are going to discuss the judicial system of India. And judicial system of India, we will be taking two sessions, one today and the next session that will be on Monday. So Sharvani, very good evening and welcome to the session, and please confirm your attendance everyone. Then we are going to initiate today's discussion, that is all about the judicial system of India. So what will be the students, shall we start the session? And in this session that is particularly dedicated to for SSC CGL examination. So this session it is completely dedicated for SSC CGL exam. And we will be taking the question that can come from CDS, that can come in CGL also, tier 1 and tier 2. So Giridhar, good evening. Ajay, good evening. So good evening everyone and welcome to the session. So welcome to the session everyone, and students, let's begin the session. Let's start the session. And today we are going to discuss the judicial system of India part 1, and on Monday we will be discussing the judicial system of India part 2. So let's start the session. And here is the first question guys before you. The Supreme Court in India was established by an act of parliament under Indian Independence Act 1947, under Government of India Act 1953, or by Constitution of India. So how Supreme Court was established? So what was how Supreme Court was established? This is the first question of the session. The Supreme Court in India was established under Act of Parliament, under Indian Independence Act, under Government of India Act 1953, or by Indian Constitution. How this is going to be established? How this is going to be established? Okay, let's see the correct answer. So Sharvani is saying option D. Okay, that is by Constitution of India. So guys, first of all, Supreme Court, that we all know it is the apex court of India. Supreme Court is the apex court of India, and that was established by Constitution of India on 26 January 1950 and started operating from 28th January 1950. So started operating from 28th January 1950 and it was established on 26th January 1950. So Government of India Act, there is no Government of India Act 1953. Earlier the Government of India Act was during the British time. So it was during the British time guys. So it should be Government of India Act 1935, not 1953, because Government of India Act that all ended before independence. So by an act of parliament it is not a statutory body at all. So Supreme Court, it is a constitutional body. Constitutional body. It is not a statutory body. It's not a statutory body. And statutory body is that body which is established through an act of parliament. So correct answer will be guys option D, by Constitution of India, established on 26 January 1950 and started operating from 28 January 1950. So correct answer will be option D. So I hope it is clear to all of you guys. It is a constitutional body, and the body which is established by an act of parliament, it is called statutory body. So body which is established by an act of parliament is called statutory body. भाई इसको थोड़ा डार्क कर दो, दिख नहीं रहा होगा. So I hope guys that should be clear to all of you. And before I should move to the next question guys, is the brightness is all right? You can see the things which is written on the smart board. So before I should proceed to the next question, is it clear to all of you what is written on the smart board? Is it all visible to you? Is it all visible to you guys? Okay, so if it is visible guys, then let's move to the next question. So that should be visible to all of you, कि whatever it is written on the smart board. Now let's come to the next question. Next question we have कि the power to increase the number of judges in Supreme Court in India is vested with whom? So who has power to increase or decrease the number of judges in Supreme Court? Is it the President of India, the Parliament, Chief Justice of India or the Law Commission? So which authority has power to increase the number of judges as well as decrease the number of judges in Supreme Court? So power to increase or decrease the number of judges in Supreme Court, who has the authority? Okay, let's see the correct answer. So Sharwani is going with option B. So power to increase or decrease, that is with the Parliament of India. So it has not only power to increase the number of judge, it has power to decrease the number of judges in Supreme Court. So it has the power to increase the number of judges, same has the power to decrease the number of judges in Supreme Court, that is with the Parliament of India. And right now guys, so the maximum strength right now, maximum strength that is being set is 34. So right now the maximum strength that is set by Supreme Court, that is 34, and presently 29 judges, they are working. So presently guys, 29 judges, they are working in the Supreme Court. Out of this, one is the Chief Justice, that is Justice Uday Umesh Lalit, and 28 is the judges. 28 is the judges. So presently we have 29 judges working, and the maximum strength that is sanctioned by the Parliament of India, that is 34. So maximum strength which is sanctioned by Parliament of India, it is 34, and maximum at presently 29 judges are working in the Supreme Court. So good evening Tariq, Purana student. So one is the Chief Justice, 28 are the judges. So present number is 29, that is the working number, and 34 it is the maximum strength of the judges. So Parliament has power to increase the number of judge, also to decrease the number of judge in the Supreme Court. So I hope it is clear to all of you, and Chief Justice of India is the senior most judge in Supreme Court, and presently we have 49th Chief Justice of India, that is Justice U. Lalit. That is Justice Uday Umesh Lalit. He is from Kolhapur. He is from Sholapur, that is in Maharashtra. So presently we have Justice Uday Umesh Lalit. So correct answer will be guys option B. Now let's move to the next question, and let's discuss what next question is for us. So that is a big question, and before you should attempt this question, please read the question carefully. What is the provision to safeguard the autonomy of the Supreme Court of India? While appointing the judges of the Supreme Court, President of India has to consult the Chief Justice. The power of the Supreme Court judge, the judge of the Supreme Court, or the Supreme Court judge, can be removed by Chief Justice of India only. The salaries of the judges, they are charged on Consolidated Fund of India. The appointment of officers and the staff of the Supreme Court of India is made by government only after consulting the Chief Justice. So out of this, which statement is true? So the question is, out of the given statement, which of them is or are true? This type of question will come in SSC CGL Tier 2. So SSC CGL Tier 2 type question. Tier 2 type question. Which statement will be the correct? And it is not like that you have not read this thing earlier. So that is all being read by everyone. Just you have to identify. Okay, so 1, 2, 3, 4. That is option D. Okay. Okay, let's see the correct answer. First of all, guys, the second statement is that the Supreme Court judges can be removed by Chief Justice of India. They cannot be removed by Chief Justice of India only. They can removed by Parliament. Parliament of India. So Parliament of India has power to remove the judges of Supreme Court. So second statement is wrong. So this statement has gone. Now the salary of the judges, they are charged on the consolidated fund. This is a correct statement. So three options that we are getting. Now appointment of the officers. Officers means other than the judges of Supreme Court. The staff of the Supreme Court is India is made by government after consulting Chief Justice. This is not mandatory. Like the exams are conducted through SSC and some internal promotional exams are also there through which the staff of the Supreme Court they got selected. So the fourth statement is wrong. So this statement is all gone. 1 and 3 is the left. Now while appointing the judges of the Supreme Court, President of India consults the Chief Justice. That is a correct statement. So this is correct and third statement is correct. So correct answer will be what? It will be option A. Not only 3, 1 and 3. Both statements they are correct. So correct answer will be what? It will be option A. Correct answer will be, guys, option A. Correct answer will be option A. Correct answer will be option A. So I hope it is clear. This type of question, they are very good questions that needs proper concept, that needs the proper concepts to answer. So that needs the proper concepts to answer. So correct answer will be, guys, option A. So this type of question, they are very good questions. Although if you are conceptually strong, then only you can answer this type of questions. So correct answer will be, guys, option A. Okay, so this thing we have read. पार्थ दवे सर बहुत से यूट्यूब चैनल वीडियो बना रहे हैं कि न्यू आरआरबी वैकेंसी 2023 में आएगी, ये सही है या फेक न्यूज़ फैला रहे हैं? अभी तक ऑफिशियली तो ऐसा कुछ नहीं है, अगर होगा तो फिर न्यूज़ प्रॉपर आएगी। ऑफिशियली अभी तक ऐसा कुछ अनाउंसमेंट नहीं है गवर्नमेंट ऑफ इंडिया की तरफ से, तो पता नहीं उनका अपना जो सोर्स है या किस सोर्स से बना रहे हैं। अभी तक ऑफिशियल ऐसा कुछ नहीं है कि 2023 में भी आरआरबी एनटीपीसी की वैकेंसी आएगी। ऐसा कुछ ऑफिशियल ना तो रेलवे की साइट पर है, ना तो किसी गवर्नमेंट ऑफ इंडिया की साइट पर है या पीआईबी की। तो ये हो सकता है कि वो बना रहे हो कि ऐसा आ सकता है, तो आ सकता है। अभी तक कोई ऑफिशियल इंफॉर्मेशन नहीं है, और जब तक ऑफिशियल नहीं हो तो फिर हम लोग भी इसको चैलेंज मतलब कंफर्म नहीं कह सकते। हो सकता है, तो ये हो सकता है टेंटेटिव वैकेंसी के फॉर्म में दिखा रहे हो। अभी तक गवर्नमेंट ऑफ इंडिया की तरफ से कोई ऑफिशियल इंफॉर्मेशन नहीं है, ना कि ना रेलवे की साइट पर है, ना तो एसएससी की साइट पर है, ना तो आरआरबीज जो डिफरेंट आरआरबीज हैं उनकी साइट पर है। So correct answer will be, guys, option A. That is first and third will be the correct statement. Now come to the next question. The Indian Constitution provides the appointment of ad hoc judges in. So where ad hoc judges they are being appointed? So where ad hoc judges they are being appointed? So ad hoc judges where they are appointed? So where the ad hoc judges, they are appointed. Okay, so ad hoc judges, they are appointed where? So first of all guys, ad hoc judges, what it means? It means the temporary judges. So ad hoc means the temporary judges. Ad hoc judges means temporary judges. See, temporary judges, they are appointed by Chief Justice after consulting with the President in Supreme Court. So ad hoc judges, they are appointed in Supreme Court by Chief Justice of India. By Chief Justice of India. By Chief Justice of India after consulting with President. After consulting with President, when there is, when number of judges is less. So what happens ki generally this type of ad hoc judges, they are appointed. They are appointed by President of India when the number of judges in Supreme Court is less. So that is ad hoc judges, they are only appointed in Supreme Court. What happens ki generally retired judges or the judges which are judges or the Chief Justice of High Courts. So judges or the Chief Justice of High Courts, they are appointed as ad hoc judges for temporary period, for temporary. Now whenever the number of judges they are being completed, they are sent back to their own position. Why temporary appointment of judges? That is it, this is just because if the number of judges is less or the quorum is less. If quorum is less, so if the number of judges are less and cases are more, so just to handle the cases when the judges are less, number of cases are more. So what happens ki the Chief Justice of India discusses with the President ki let's appoint some ad hoc judges, and these ad hoc judges either they are the retired judge of the Supreme Court or they are the Chief Justice of High Court to whosoever the President wishes or the Chief Justice wishes to let them come in the Supreme Court. Now they handle the cases. By the time they are working as a judge, they get the salary and privileges of the judges of Supreme Court. Now once the number of judges gets complete and Chief Justice is assured that now the judges of the Supreme Court can handle that cases, so they are sent back to their previous position. So this is the thing. Why ad hoc judges term we can use? Because they are temporary, and ad hoc simply means temporary. Ad hoc means temporary. So these are temporary judges who are being called in Supreme Court once the number of cases are more and the number of judges are less. So this is why the ad hoc judges are being appointed. And in High Court, additional judges are appointed. Additional judges are appointed, and in High Court additional judges are appointed. So additional judges are appointed in High Court, ad hoc judges are appointed in Supreme Court. So ad hoc judges in Supreme Court, additional judges in High Court. And you will find that this additional judges, they are the judges on probation period. Additional judges, they are judges in High Court for probation. So on probation, the judges of High Court. On probation, the judges of High Court. So correct answer will be option A. That is ad hoc judges, they are only only appointed in the Supreme Court once the number of cases are more and the number of judges are less. And ad hoc simply means the temporary judge. So ad hoc simply means the temporary judge. So correct answer will be option A. Now come to the next question, guys. So that is the ad hoc. So ad hoc itself means the temporary. Ad hoc itself means the temporary. Now the minimum number of judges of the Supreme Court which is required for the hearing of the case involvement interpretation of Constitution. So what is the minimum number of judges required for the interpretation of Constitution? The number of judges required for the interpretation of the Constitution. Okay, let's see the correct answer. So minimum number of judges for interpreting the Constitution of India, because Supreme Court is the custodian and interpreter of Indian Constitution. Because Supreme Court is custodian and interpreter of Indian Constitution. Custodian and interpreter of Indian Constitution. So for a case related to the interpretation of Constitution, minimum 5 judges bench they are constituted. So minimum 5 judges bench they are constituted and decision is taken through majority. Decision is taken through majority, कि whatever the decision of majority will be there, that will be implemented, and this type of bench is called Constitution bench. Constitution bench. And in Constitution bench always odd number of judges are kept. Odd number of judges they are kept so that the decision can be taken through majority. So that the decision can be taken through majority. Therefore, every time the odd number judges bench they are constituted so that you can take any decision through majority. So correct answer will be, guys, option D 5, and maximum that was constituted in Keshwanand Bharti, that was 13 judges bench. Maximum number that was 13 judges bench. That was in Keshwanand Bharti case. State of Kerala case 1973. So Keshwanand Bharti versus State of Kerala case 1973. So that was the number of judges in the Supreme Court. So 5 judges bench that is being constituted. So every time that is 5 judges bench, minimum it is 5, but it can be 7, it can be 9, it can be 11, it can be 13, 15. Every time odd number of judges is considered so that the decision can be taken through majority. So correct answer will be, guys, option D, that is 5 judges bench. 13 जजेस बेंच को क्या बोलते हैं? उसको कुछ नहीं बोलते हैं, उसको भी कॉन्स्टिट्यूशनल ही केस होगा तो कॉन्स्टिट्यूशनल बेंच बोलेंगे. 2 जजेस बेंच को क्या कहते हैं? डिवीजन बेंच कहते हैं. डिवीजन का मतलब होता है मोर देन 1. तो मोर देन 1 जब भी बेंच बनता है उसको डिवीजन बेंच कहते हैं. तो वो 13 जजेस बेंच भी होगा, उसको डिवीजन बेंच ही बोलते हैं. और सुप्रीम कोर्ट हमेशा डिवीजन बेंच बनाता है, सिंगल जज की हियरिंग नहीं होती. सिंगल जज की हियरिंग होती है सिर्फ हाई कोर्ट में, डिवीजन बेंच हमेशा सुप्रीम कोर्ट में बनता है. तो मोर देन 1 जजेस दैट इज कॉल्ड डिवीजन बेंच, एंड डिवीजन बेंच इज ऑलवेज कॉन्स्टिट्यूटेड इन सुप्रीम कोर्ट, and single judge bench is constituted in high court. So in high court normally you will find 1 judge is sitting. There also division bench is considered, but that is totally on the discretion of the chief justice. But in Supreme Court always division bench is created. So more than 1, that all comes under division bench. If more than 1 judges are there, all it comes under division bench. Okay, now guys come to the next question कि the Supreme Court Collegium comprises of the Chief Justice of India and few senior judges for recommending the appointee to the Supreme Court. The number of such senior judges who are the part of this body is. So, number of judges in the Supreme Court Collegium other than Chief Justice. What is the number of judges other than Chief Justice in the Collegium of Supreme Court? Okay, let's see the correct answer guys कि the number of judges in the division in the collegium system. Guys, collegium system, total it has 5 judges. Total it is 5 judges. So collegium system guys, total it has 5 judges. Total it has 5 judges. Out of this 5 judges, out of the 5 judges, one will be the Chief Justice and 4 will be the next senior most judge. Next senior most judge after CJI. So total we have, other than CJI, total we have 4 judges. Because the question is asking comprises of the Chief Justice of India and few senior. So few means 4 senior most judges after Chief Justice. Collegium system is used to appoint the judges in the Supreme Court. So it is collegium system. Collegium system that recommends the name for appointment of judges in Supreme Court. So in Supreme Court guys, collegium system is used for appointment of the judges and total it has 5 judges. Total it has 5 judges. One will be the Chief Justice of India who will lead the collegium, and other than this 4 senior most judge after Chief Justice. So other than this 4 senior most judge after Chief Justice. So that makes the collegium. So correct answer will be guys option B, that is 4. Correct answer will be option B, that is 4. So correct answer will be guys option B, that is 4 judges. Now let's come to the next question, and before I should move to the next question guys, first of all I will request all the students who are new to our channel, then please download the Exampur official app. Why to download the Exampur official app? Because we are giving the free job alerts, then structured paid courses with on affordable fee, then free PDFs of the session, unlimited quiz to practice, then free previous year solved papers, and you will be getting the current affairs, and this current affairs that will be compiled on daily basis, weekly basis, and third will be the monthly basis. Daily, weekly and monthly basis bilingually. So good evening Swati, and this is, other than this we are also conducting the All India test so that you can evaluate your performance at what level you are standing right now. सर 5 हटा है। ओहो, so total we have the 5 judges. No, so total that is right, because few senior is there is asking, so that will be the 4. Total we have 5, that includes the Chief Justice, and in question it is asking other than Chief Justice. That in question it is asking other than Chief Justice. So other than Chief Justice it is 4, including Chief Justice it is 5. So that is correct guys, because we are asking the few senior. So few means other than Chief Justice, few means other than Chief Justice. So that will be 4. That will be 4. So that will be the 4, answer is correct. So that will be the 4 judges. Other than Chief Justice the question is asking. So I told you about the features of the Exampo app. Now we are going to discuss about the how to download Exampo app. First of all guys, there are few simple steps. First of all, you have to go to Google Play Store. We have only the Android version. We have only the Android version, we don't have the iOS version. Then just you have to type Exampo. Once you will type Exampo, it will look like this. Exampo Sarkari Naukri Prep. For the first time if you are using, click on install, and if you are the first time user, then you have to click on let's register. If you are a first time user, then you have to click on let's register. Then a small form will be open before you. You have to fill basic details. Then you have to tick the checkbox and you have to click on let's register. Once you will click on let's register, the app will get registered and you can start using the facilities other than paid courses. And paid courses are such a courses which are designed exclusively and on a very affordable fees. So on a very affordable fees that you will be getting the paid courses as well. Now guys, come to the next question. Next question we have कि the pension of a retired judge of the High Court is charged on. So where you will find कि the pension of the judges, retired judges of the High Court, they are charged. Is it they are charged on consolidated fund of the India, consolidated fund of the state where he has last served, consolidated fund of the different states where he has served, or contingency fund of India? हाँ, बिल्कुल मॉक टेस्ट भी दे सकते हो इसमें बिना किसी चार्ज के, बिल्कुल मॉक टेस्ट दे सकते हो, सेक्शनल भी मिल जाएगा. So the next question before you is कि the pension of the retired judges of High Court, how they are being charged? How they are being charged? So they are being charged guys the pension of the retired judge of the High Court. Retirement age is 62 years. And if I talk about the salary of judges of High Court, they are charged on consolidated fund of state, and pension, it is charged on consolidated fund of India. So pension after retirement, it is charged on consolidated fund of India. So the pension that will be from consolidated fund of India. And if I talk about Supreme Court judges, both salary and pension, both salary plus pension, they are charged on consolidated fund of India. Both they are charged on consolidated fund of India if I talk about the salary and pension. So consolidated fund of India, that will be the correct answer. Contingency fund is guys simply it is an emergency fund. Emergency fund under precedent and operated by Finance Secretary. Under President and operated by Finance Secretary. So, correct answer will be guys option A, that is the Consolidated Fund of India. So, under this the pension of retired judges of the High Court, they are being charged. So, I am on the one side of the screen so that you can note down the important points that is related to the President of India. So, that is related to the President. Consolidated and contingency fund. Contingency fund, it is an emergency fund which is used in unforeseen condition. Consolidated fund is the largest fund under government of India from where the salary, the pensions and other things are being given. So, every type of expenditure that is being there. So, consolidated fund is the largest fund that is under government of India. Contingency fund, it is always used in emergency condition. So, if government of India wishes to purchase anything, then that amount of that purchase is given from the consolidated fund. भारत को मिसाइल खरीदना है तो पैसा कहाँ से आता है? वो कंसोलिडेटेड फंड से निकलता है. एमपीज, एमएलएज, राष्ट्रपति, एमपीज की सैलरी, राष्ट्रपति की सैलरी, ये सारी चीज़ें निकालनी होती है, वो कंसोलिडेटेड फंड से निकलता है. कंटीजेंसी फंड हमेशा इमरजेंसी में यूज़ किया जाता है, जैसे लड़ाई हो गई या कहीं कोई नेचुरल कैलामिटी आ गई तो उसमें जो पैसा निकलता है वो कंटीजेंसी फंड से निकलता है, इसलिए इसको इमरजेंसी फंड कहते हैं. ये भारत सरकार का रेगुलर फंड है. प्रेसिडेंट के अंडर is always contingency fund. Consolidated fund, it is under Parliament of India. So, it is under Parliament. It is under the Parliament of India. So, consolidated fund is under Parliament of India. Now, come to the next question guys. Next question is very easy. So, consolidated fund, it is under Parliament, whereas contingency fund, it is always under the President. Now, let's come to the next question. Next question we have कि the High Court judges address his letter of resignation to whom? PM के अंडर कोई फंड नहीं, PM के अंडर कोई फंड नहीं होता. कॉन्स्टिट्यूशनल फंड्स पीएम के अंडर नहीं होता. पीएम केयर वगैरह यूज होता है तो वो कोई कॉन्स्टिट्यूशनल फंड नहीं है. पीएम केयर जो फंड है वो प्राइम मिनिस्टर के अंडर में होता है, वो कोई कॉन्स्टिट्यूशनल फंड नहीं है. Now the High Court judges address the resignation letter to whom? So High Court judges, they address the resignation. So if a judge of a High Court wants to resign, to whom he will give the resignation letter? Okay, let's see the correct answer. See, High Court, that is defined in part 6 and that is article 214 to 231 and that is being given to the President of India. So High Court judges, they resign by writing to the President of India because President of India appoints the judges. Appoints the judges of Supreme Court and High Courts. They are appointed by President. They are appointed by President. So, correct answer will be guys option A, that is the President of India. President of India appoints the judges of the Supreme Court or High Court. So, correct answer will be guys option A. That is the President of India. President of India can appoint the judges and if any judges wishes to resign, then can also resign by writing to the President of India. So, every time that will be the President, Governor that conducts the oath of the judges. Oath of the judges of Supreme Court, of High Courts. Governor appoints the oath of the judges of High Courts. So, oath of the judges, total number of funds under mentioned, that is 3. Total number of funds under Constitution, total funds under Constitution, that is 3. Consolidated fund, public account fund and contingency fund. Consolidated public account and contingency fund. So these are the three funds which is under the Constitution of India. Consolidated public account fund and contingency fund. Now come to the next question. Ki the term district judge, it is mentioned in which of the following articles of Indian Constitution? The term district judge. District judge term, it is mentioned in which article of Indian Constitution? The term district judge. Term district judge, it is mentioned in which article of the Indian Constitution? Okay, so the term district judge. See, first of all, district judge, that is under subordinate court. Subordinate court. It is defined in part 6, article 233 to article 237. So from article 233 to 237, that we have subordinate courts and high courts. That is in part 6, article 214 to 231. So 214 to 231, that is under high court, and subordinate court, that is article 233. And subordinate courts, that is the lowermost judiciary at the state level. So subordinate court, lowermost judiciary at state level. Lowermost judiciary at state level, that is called subordinate court, and they are being provisioned, they are being monitored by high court. So they are being monitored by high court. So they are being monitored by high court. 233 to 237, that is the articles of subordinate court. So 233 it is mentioned, therefore this will discuss about the district judge, because district judge, it is always in subordinate court. District judge is always in subordinate court. It is always in subordinate court. So correct answer will be, guys, option D. So I hope it is clear to all of you about subordinate court. Subordinate court is the lowermost judiciary in the judicial system of India. So highest judiciary, Supreme Court, then middle level judiciary, high courts, and the lowermost judiciary, it is subordinate courts. And subordinate court and the highest subordinate court is district and session court. It is district and session court that operates at district level. That operates at district level. So correct answer this. Who can appoint the judges? Judges are appointed by governor. Judges in subordinate court, they are appointed by governor. So judges, they are appointed by governor. So governor of a state, that appoints the judges of the district court or session, district and session court. So they are appointed by governor. So is it clear to everyone? ओके सर, सेशन जज किसको बोलता है? सेशन जज जो क्रिमिनल केसेस देखता है, सेशन जज जो होता है वो क्रिमिनल केसेस देखते हैं। डिस्ट्रिक्ट जज जो सिविल केसेस, जो सिविल केसेस देखते हैं उसको डिस्ट्रिक्ट जज कहते हैं, जो क्रिमिनल केसेस देखते हैं उसको सेशन जज कहते हैं। सो करेक्ट आंसर विल बी ऑप्शन ए। Now come to the next question कि against which judge Rajya Sabha passed a motion of impeachment in 2011 but he resigned to save himself before it could be passed by Lok Sabha. So there was a judge against whom the removal process was started, but in 2011 by Rajya Sabha, but in order to save himself, that means in order to save the dignity of the post of the judge, finally he resigned himself from the judge. Who was he? So against whose person there was a process of removal that was being started, but before it should be introduced to the Lok Sabha and can get passed to the Lok Sabha and reaches the president, that judge himself resigned. That judge himself resigned. Is it Justice V. Ramaswamy, Justice Bhattacharya, Justice Soumitra Sen or P.D. Dinakaran? So in 2011, against Justice V. Ramaswamy, the impeachment was not, the removal was not being completed because it was being passed by Lok Sabha, defeated in Rajya Sabha. So correct answer will be Justice Soumitra Sen. So Soumitra Sen, his name, so he was earlier Chief Justice of Kolkata High Court. Kolkata High Court, and he was going to get elevated. So he was being elevated as judge in Supreme Court. So finally his name came in scam of purchasing furniture. Furniture of high courts. Of high court. So he resigned himself. So in order to save the dignity of the post, he resigned himself. So he resigned himself. So that is Justice Soumitra Sen. So that is Justice Soumitra Sen. So correct answer will be option C. That is Justice Soumitra Sen. No, it is technically it is removal, it is not impeachment. So technically it is removal. And impeachment it is only for the president. Impeachment it is only for the president. For rest of the post it is removal. Technically impeachment is only for the president. Technically impeachment is only for the president. For rest of the post it is removal. Okay, so technically it is removal. For rest of the post it is impeachment. So in rest of the post it is removal. Technically it is for the impeachment. Now under preventive detention a person can be detained without trial for a period of. So under preventive detention, हाँ, लोकसभा से impeachment नहीं हुआ था, लोकसभा से resolution पास हुआ था. Impeachment दोनों houses के बाद होता है. So under preventive detention a person can be detained for how many time period? So under preventive detention a person can be detained for how many time period? So guys, for a preventive detention, that is generally did to in order to maintain the law and order. So under this is done to maintain the law and order, and that is the preventive detention, that is detention without trial, that is did for the 3 months. That is did for the 3 months. So that is did for the 3 months, that is prevention without trial, that is did for the 3 months. So correct answer will be guys option B, that is 3 months a person can be held, that is without trial. So correct answer will be 3 months, not for 6 months. This is the maximum time period. Although it can be increased by the parliament, but as of now it is 3 months. Now come to the next question, ki who is the last authority to explain the Constitution of India? So who is the last authority to explain the Constitution of India? Is it President, Attorney General, Speaker or Supreme Court? Who is the last authority to explain the Constitution of India? So who is the last authority to explain the Constitution of India? So last authority to explain the Constitution of India, guys, that is the Supreme Court. So Supreme Court is the last authority to explain the Constitution of India, that is Supreme Court. It is Supreme Court of India. PDL, ये PDL लॉ में होता है, ये PDL वीडीएल नहीं समझ में आता भाई, पूरा लिखो. प्रिवेंटिव डिटेंशन लॉ, प्रिवेंटिव डिटेंशन में बिना किसी ट्रायल के चला ही रख लेते हैं, घर में नजरबंद कर लेते हैं, उसी को प्रिवेंटिव डिटेंशन कहते हैं. घर में ही नजरबंद करके रख लेते हैं. Attorney General is the highest law officer of India. He does not have to explain the Constitution. So that is Supreme Court, because Supreme Court is the custodian and interpreter of Indian Constitution. Now guys, next question is ki who has right to seek advisory opinion of the Supreme Court on any question of law? So who has right to seek advisory opinion of the Supreme Court under any question of law? So under any question of the law, who has right to seek the opinion from the Supreme Court? Right to seek the opinion under the Supreme Court, which authority has? So right to seek the opinion under the law, that is did by the President of India only. So President of India can take advice the Supreme Court on legal matters. So Supreme Court can take the President can take the advice of Supreme Court in legal matters. Now guys, next question is कि to become the judge of a Supreme Court, a person must be an advocate in High Court for at least how many years? हाँ, 3 months तक का without any trial, definitely for 3 months without any trial. Next is कि to become the judge of the Supreme Court, a person must be an advocate in High Court for at least how many time period? 20, 10, 8 or 25. So for how many time period you must have served as an advocate in one or more than one High Courts? So for one and more than one High Court, you must have served as the advocate for 10 years. So advocate for 10 years, judge for 5 years. Judge for 5 years, advocate for 10 years. Now guys, next question is कि which article of the Constitution has been prohibited from inquiring the proceedings of the Parliament? So through which article of the Constitution Supreme Courts they are prohibited, or the judiciary is prohibited, or the Supreme Court is prohibited from inquiring the proceedings of the Parliament? That means कि under which article Supreme Court or High Court they are not authorized to see the things that is related to the proceeding of the Parliament. That means they will not interfere in the proceedings of the Parliament. Through which article it is there? Article 130, 122, 124 or 169. So First of all guys, what will be the correct answer? Sharwani article 169 that discusses with the Legislative Council. 130 permanent seat of Supreme Court that is in Delhi. Then article 124, there shall be Supreme Court of India, and article 122 will be the correct answer. So 122 will be the correct answer. Okay guys, so students, with this we sum up with the end of our today's session, and this was all about the judicial system of India. And tomorrow you have a marathon from 11 a.m. to 1 p.m. on English medium prep by example. So you have the marathon session as well. So guys, that was all for today's discussion. Let's meet again at 11 a.m. for a marathon session on Indian. That will be a mixed question marathon session. So that's all for the day guys. Let's meet tomorrow for the marathon session. Till then, bye bye everyone. Do take good care of yourself.